Thank you, Chairman Gallego, Ranking Member Gassar, and members of the subcommittee, and also Representative Neguse for that overly generous introduction. I hope you don't get me back with a few key questions like I did perhaps to you in law school. I'm really honored to be able to testify at this important hearing. My name is Sarah Krakoff, and I am a law professor at the University of Colorado. I hope my remarks will be of use to the committee. As Chairman Norris described, construction crews are blasting an Organ Pipe National Monument and have already destroyed indigenous burial grounds. Many additional sites are at risk along the more than 1,900 miles of the U.S.-Mexico border. I would like to make 2 points about this. First, the administration's approach to building the wall has disproportionate impacts on American Indian tribes because of their unique ties to federal public lands. Second, the damage is avoidable, but is a predictable consequence of the administration's sweeping waivers of federal laws, which deprive the federal agencies, the tribes, and the American public of the information necessary to decide whether the benefits of the wall outweigh its human and environmental costs. With regard to the first point, tribes' historic territories extended well beyond their current reservation boundaries. Tribes therefore have religious, cultural, and historic sites throughout federal public lands. Hundreds of treaties, federal laws, and executive orders recognize this by affirming that tribes have rights that extend beyond their current reservation boundaries. Specific laws and policies would normally protect tribal rights on federal public lands, including the following: the American Indian Religious Freedom Act, which states that it is the policy of the United States to protect American Indians' inherent right of freedom to exercise their traditional religions, including access to sacred sites. The National Historic Preservation Act, which protects traditional and cultural properties on federal public lands. The Archaeological Resources Protection Act, which requires permits for excavation or destruction of archaeological resources on public lands. And the Native American Graves Protection and Repatriation Act, which provides protections for Native American burial and archaeological sites on public lands. Two bedrock environmental statutes, the National Environmental Policy Act and the Endangered Species Act, would also normally protect tribes and the public's interests in public lands. This leads to the second point. Why, despite all of these laws, are construction crews blasting in national monuments and wildlife preserves? The answer is that the Secretary of Homeland Security has waived the application of dozens of laws, including all of those mentioned above. The Secretary's power comes from Section 102 of the Real ID Act of 2005, which authorized the waiver of all laws that could impede the expeditious construction of barriers and fences. Initially, despite the breadth of the waiver power, the Secretary's authority was somewhat bounded by the fact that in the Secure Fence Act of 2006, Congress only authorized expenditures for roughly 700 miles of fences and barriers. The Secretary's waivers could only extend to the areas that Congress had specifically authorized for construction. This is not to understate the human, environmental, and cultural impacts that resulted from those initial stretches of a border fence. They were considerable, including flooding of Nogales and other areas, deaths of rare and protected wildlife, and destruction of wildlife migration corridors. But impacts from the pre-existing border fence will pale in comparison to the effects of the current administration's indiscriminate use of waivers. For context, the Bush administration exercised the waiver 4 times for 5 projects. The Obama administration did not exercise the waiver at all. The Trump administration, acting without congressional authorization for its border wall, has already exercised the waiver provision 15 times. The waivers have covered between 29 and 37 statutes, including all of those listed above, as well as the Antiquities Act, the Wilderness Act, and the Federal Lands Policy and Management Act. To summarize, the administration is heedlessly destroying irreplaceable resources in which Native nations have unique interests by setting aside all of the legal protections that were carefully designed to protect tribes and all other Americans. None of this is necessary. Even if a border-long barrier were an important goal, it could be completed without suspending all of our environmental and other protective laws, but it could not be completed on the administration's political timetable. The federal government has long recognized that its broad powers in Indian affairs are or should be accompanied by a corresponding solemn obligation to honor the rights and interests of the peoples who preceded us on the continent. Instead of furthering this trust obligation, the administration is exercising its executive power in derogation of tribal rights. Thank you for the opportunity to testify. I look forward to any questions you may have.